In the weeks before your hearing, you and the defendant's attorney can prepare by exchanging information about each other's cases. This is called discovery. You may receive written questions called interrogatories in the mail from defendants. You must respond in writing to these questions by the deadline given. You also have the right to ask questions by sending them in writing to the defendant's counsel. Ask the defendant's attorney to send you documents you want from the employer or insurance company. You may receive a notice at the defendant's request directing you to be examined by a doctor. Note the date, time, and location. If there is a problem with the date set for your medical examination, call the defendant's attorney to ask for another date or time and write the judge. The judge must receive your letter within 3 days of the date when you receive your notice of examination. Defendants pay for your medical examination, but you must keep the appointment. Failure to attend can result in penalty fees, sanctions, or forfeiture of your claim. When you go to an examination, you have the right to tape record it and/or bring a doctor with you. You should tell the defendant's attorney in advance if you plan to do this. You are entitled to get a copy of the doctor's report. You may receive a notice of deposition. Note the date, time, and location. You must attend. If there is a problem with the date, immediately call and ask the defendant's attorney for another date or time. If that does not work, promptly write a letter to the judge and explain your problem. Unless the judge excuses your attendance in advance, you must attend. A deposition is a question and answer session with the defendant's attorney, usually at the attorney's office, but sometimes by telephone. At the deposition, you answer questions under oath. A court reporter will record your answers. If you need an interpreter, let the attorney know in advance and one will be provided. This is your opportunity to tell the defendants what you want in your claim. Sometimes it is possible to settle cases before the hearing. You might want to discuss this possibility with the defendant's lawyer at your deposition. Sometimes the judge will want to talk with you and the defendant's attorney before the hearing. If so, you will receive a notice for a pre-hearing conference in the mail, or the judge's secretary may call you to set up a time for the conference. Put the date, time, and location on your calendar. Usually, the conferences are conducted by telephone, but not always. Be sure to follow the instructions on the notice, and if asked to do so, call the judge's secretary and confirm the telephone number. Request an interpreter if needed. You may only talk to the judge if the defendant's attorney is present. The judge will usually identify the issue that will be considered at the hearing and briefly discuss the rules and the law that you will have to follow. The judge may ask you about witnesses or evidence you plan to use at the hearing.